we're going to kick the event off promptly at crowd online because we simulcast these events. So welcome to everybody there, and thank you for joining us. My name is Guy Lehman. I just want to welcome you to Compass Financial. I'm an owner and advisor here, and I am actually in charge of educational events. So we have 2 economic updates every year, one in January and then one mid-year in July. In the spring, we have a Social Security event every year. Generates a lot of interest, a lot of questions. You know, it's a very prominent part of many people's financial plan, and they want to educate themselves on it. So that will be coming up in April. In October, we have our Medicare event. Not to be confused with what we'll be talking about today, which is Medicaid. Completely different program. Okay, so Medicare is the government health insurance option at age 65. That's Medicare. We won't be talking about that today. We'll be talking about Medicaid. Also, if you have ideas throughout the year of something that you'd like to learn or like us to potentially host an event, I'd love to hear from you because we do these most of the months. Yes. Next month, we have an event called Farm Succession Planning. And this is an event that touches a lot of families in Iowa. And if you haven't inherited land, I bet you know someone that has. And there's a lot that goes into how people plan to hand land and farms off and on both ends. So the generation that owns it now and is preparing to hand it to the next generation, or the generation that will be receiving it. Because there's a lot of people who still have parents alive that own farmland. So join us next month. We're going to have some experts in that are deep in this area, give us some examples about what people are doing successfully and how to think through all that stuff. So join us next month. I want to acknowledge our advisors. We have Michelle Bjorkren. Where's Michelle at? There she is. Alan Holstein. Thank you. Caleb Pearson, thanks for running this. Kurt's here. Where's Kurt? There you are. I can't see you with the light, sorry. Justin Van Houten, Mandy Rhodes, and Steve Connard. And our other staff, Cheryl Hurst, was checking us in. Thanks, Cheryl. Julie Greer. Joe Wanniger is not here today. Nancy Economist and Hannah Mason. All right, that's the Compass team. Okay, I am going to introduce Chad Eichhorn. He is going to talk about estate planning in general and then focus in on Medicaid planning. Chad and I met about a year ago. We had a joint client interaction. And after that meeting, I was really impressed by Chad's wisdom, his graciousness, and his care for our joint client. And we got to know each other a little bit. And I learned that this is one of the focuses of Chad's legal practice. He works for Pearson Bowman Law Firm right down the street. They have offices in all over Iowa. But he does Medicaid strategy and Medicaid planning. So I want to welcome Chad. Thank you for coming today. You got your mic on? Okay. Tell us a little bit about yourself. And I will say I've looked through his presentation. The first half is kind of some general estate stuff, trusts and wills and powers of attorney and why things matter. And then the second half is digging into this Medicaid planning idea.
Exactly right.
Thank you.
So first of all, very good to see you guys. Thanks very much for coming in today. As Guy said, my name is Chad Eichhorn. I'm an attorney at Pearson Bowman Law. Our firm specializes in estate planning and planning to help people qualify for benefits when either themselves or their loved ones are on their way into an assisted living or long-term care facility. So we do a lot of work trying to help people preserve resources. Just like Guy said, you know, our firm does basically just estate planning, probate, elder law, which includes Medicaid planning, VA pension planning, guardianships, conservatorships, things like that. Offices, various places, and we're part of a variety of organizations that we try to make sure that we know what we're talking about. So what we're going to talk about are protecting resources. We're going to talk a little bit about estate planning stuff. The reason that we're going to talk about some basic stuff about wills and trusts and things like that is because, especially when it comes to the trust side of things, One of the key tools that we use to help people qualify for benefits is a variety of trust planning that we do. Then it helps be able to situate the two revocable trust and irrevocable trust against each other. So first question, how many of you guys have ever done any sort of estate planning? Yeah, some of you, most of you. Trick question, of course. Everybody has done estate planning. The question is whether or not you've decided to do your own planning or whether you've decided to allow the state's legislature to do it for you. Because people die every day without anything in place, and that's when the state's laws dictate where things are going to go. So it's always a good idea for you to set up your own planning to make sure that we know where things are going to go. So what we're going to do is we're going to talk a little bit about the differences between will and trust-based planning, hit on some high-level stuff about power of attorney documents, and then living wills. So both wills and trusts are designed to do the same thing. They say, here's where I want my things to go when I'm gone, and this is the person that I want to be in charge of getting them out of my pocket and into the pocket of my loved ones. The two biggest differences are, number one, how they're effective, or when they're effective, I should say, and number two, how they're administered after I'm gone. In Iowa, we do a lot of trust planning for probate avoidance purposes. Probate is the court's oversight of getting our things out of our pockets and into the pockets of our kids. People want to try to avoid that if they can because of the cost. Have any of you ever been through a probate before? Yes? How was the experience? Long. It's what everybody says. It takes forever. It's expensive. Nobody likes each other when it's done because it should have taken half of the amount of time. And so people try to avoid going through probate. One of the common misconceptions is, well, you know, I don't have that much money, so probate won't be a deal. Probate still, it just takes forever. And so a lot of people try to avoid it. If you own property in multiple states, it's really important to avoid probate because there's a good chance that you may have to open probates in multiple states to deal with real estate that you have in multiple states. With a will, it gets submitted to the probate court. If you do, so the wills most often lead to probate. And the reason for that is real estate. If you own a piece of real estate and during your lifetime, I say, I'm going to sign a deed, I'm going to put it in my kids' names, that's great. If you're going to give it to your next door neighbor, totally fine. Whatever you want to do with it. But the moment that you're gone, the state says, well, in order for your real estate to be transferred to you, to whoever it's going to go to, the court has to sign off on it. You have to get what's called a court officer's deed. You don't get a court officer's deed until you're in front of a judge. And once you're in front of a judge, you got to go through the whole process of going through probate. So if you have a will and you own real estate, you're likely going to go through probate. If you don't own real estate, you can avoid probate just by having beneficiaries designated on your things. You can be worth $10 million, but if it's all in just your checking account and an investment account and some CDs, if they all have designated beneficiaries on them, there's nothing that the court needs to deal with. It's owning land that pulls us into probate most often. So if you have a will and you own real estate, there's a good chance you're going to go through probate. One reason that people don't like going through probate is that it's not private. If you're nosy and your next door neighbor dies and you want to see how much money they had and who they owed what to and what they had in their retirement account and how much life insurance they had, during that probate process, there's a report and inventory that's filled out. You can go online and see every last nickel that your neighbor has when they die. Some people don't like that. The administration, because it's not governed by the court, none of it's public record. So there's some privacy benefits there. Time, you mentioned that it takes forever to go through probate. I don't know what in the world is going on with the Department of Revenue right now, but it is taking forever for us to get things like tax clearances back on inheritance tax returns that we file. So things take forever to begin with, and they only slow down. And then the cost, and this is one of the biggest drivers of things. So the way that fees work when you go through probate is the statutory maximum, if your estate is worth more than $200,000, for the attorney is 2%. So if you have an estate that's worth $1 million, the attorney is going to get paid $20,000 likely to take your estate through the probate process. If it's worth $2 million, it's It's going to be, the attorney's going to get 40. The reality is, not to tell on attorneys here, but if grandma dies and grandma has a small house and a little bit of money saved for retirement and some money in her checking account, and the whole thing's worth $300,000, but grandpa dies and his estate, bigger house, more money in checking, much larger retirement account, and he's worth $3 million, it's the same amount of work for me to do grandma's estate versus grandpa's estate. I just get paid 10 times more to do grandpa's estate because his estate is worth 10 times more money. Which is one of the reasons that people try to avoid going through probate. You can guess who wrote the rules that dictate how those things go. With a trust, the goal is to avoid probate. And when I'm talking about trusts in this situation, I'm talking about just a general, what we call a revocable trust. A revocable trust is like your shadow. It sort of goes where you go and does what you do. You know, you change the title of your real estate to the trust. It allows you to avoid probate, but it's still sort of part of who you are. Advantages to trust-based planning: there's no probate. The whole goal is to avoid that process. It's private, so there's not that public information about what you own and who it's going to. It's usually much faster than going through probate because there's fewer administrative steps. It's not nearly as dependent on attorneys. And so when people come in to have us do the trust administration process after somebody passes away, we just basically charge them hourly. There's a checklist of items that need to happen. What do you want to do? What do you want to have the accountant do? What do you want to have the attorney do? Sometimes people come in and, like me, they're frugal, and so they say, I don't want to pay you to do anything. I want to handle as much of it myself as I can. Perfectly fine. We give them sort of marching orders as to the things that they need to do, and we move through that process with them. Some people come in and they just have a garbage bag full of their parents' bills and account statements and things like that, and they say, I don't want to do any of this. You figure it out. Fine, we do that too. And even in situations like that, it's usually way less expensive than going through the probate process. So then there's attorney fees are billed hourly, no core costs on that. So the question is, should everybody have a trust? And the answer to that question is no. It all depends on your family circumstances. You know, wills are perfectly fine tools for young families. Like I said before, if you don't own real estate, it's not likely that you may need a revocable trust like this. So if you're really disorganized, maybe a trust isn't the right tool for you because there's some ongoing management stuff that you got to keep track of. Or if you're more than likely going to have conflict in your family, sometimes that makes do absolutely crazy things in the courtroom just like I've had them do crazy things in my own office. Not that this is story time or anything, but I once had people in front of a judge argue about who is getting, and I'm not joking, which can of green beans was French cut, and so they thought that the increase in value of the can of green beans should be determined. The judge quickly told them to buzz off. It was wild. So, in addition to the determination about that sort of central document you have between a will and a trust, there are three that are really, really important. Power of attorney documents, one for your finances, one for your health care, and living will. These oftentimes get sort of brushed aside as sort of little things that you include with your documents. When these go wrong, they go really, really wrong. And so you want to be very careful that you have your power of attorney documents set up the way that you want them. For your financial power of attorney, usually that's taking care of your business affairs, right? Your people that can deal with your real estate and your personal property and your investments and your banking and talking to your insurance company and doing your taxes, those sorts of things. If you have an old power of attorney document, then it's a good idea to have it updated. The new forms have some expanded powers that you can authorize people to interact with you on behalf of. You got to be really careful with how you're setting those up because it would allow your loved ones to do things like change your beneficiary designations on your investment accounts, to update your estate planning in the way that they see fit, which is even people that are, good, kind, well-meaning people, money makes people do bad things. And so you got to be really careful with what you're authorizing somebody to do and not do for you. This is something I hear every once in a while. I'm not sure if I need a power of attorney. I'm just going to put my kids on my account. So putting your kids on your account as a signer is fine. Putting your kids on your account as a power of attorney is fine. Making your kids the co-owners of your accounts is oftentimes a really poor idea. And sometimes you don't even know what you're doing when you go into the bank. You go into the bank and you say, I want to put my kids on my account. The banker may not be that familiar, and they add your kids on as a joint owner on your account. Well, the problem with that is if your children are joint owners on your accounts, what happens if your child gets divorced? Now your account is part of their marital property, subject to divorce lawyers' claw to try to pull as much house as they can. What happens if they run a stop sign and they injure somebody and they get sued? Well, now your checking account is part of their property. That's going to go on a asset spreadsheet. The person's resources are going to be divided up. What happens if they die before you do? Now your checking account is part of that child's estate. All things that you got to be really careful when you're talking about, hey, I'm going to sort of my kids are going to do this. I'm going to put my kids on my account, and that's going to make up for being my power of attorney. A better way always is to name your kids or whoever as your financial power of attorney, and then just put a payable on death designation on your account. So that way, something happens to you, you already have a plan for what's going to happen with that account. It allows for the management of your accounts during your lifetime and the distribution of your accounts after you're gone. Co-ownership is very dangerous, and we see that go sideways pretty frequently. Healthcare power of attorney. Healthcare power of attorney should have three things on it. Number one, it should have a living will that we're going to talk about in just a second. Number two, it should have who's making medical decisions for you. And number three, it should have a HIPAA release. Not only do you want to say that my spouse and then my kids can make decisions for me if I'm in the hospital and unable to make my own medical decisions, you also need to make sure that the hospital is authorized to provide medical information to your decision makers. So that way you don't have a one-way street where my kids can make decisions for me, but the hospital can't tell them what's going on. And then when it comes to a living will can be a very simple statement that just says, if I am at the end of a terminal illness or I've had some sort of catastrophic event, and the only thing that prolonging my life is going to do is cause me to suffer for longer, just allow me to pass as peacefully as possible. So those are the major things that are in any good estate planning package. You've got the central document that you're going to use to determine where things are going to go, and you have the supporting documents that say, okay, well, who's going to help me with what while I'm still alive? Some other considerations. When it comes to thinking about leaving money to people, should money be left to people in trust or just outright? If you've got a disabled beneficiary, we have to be super careful with how we're going to leave money to them. I have a cousin who has Down syndrome. If he outlives his parents, we don't want their money to go into his pocket directly because it would impact his ability to access the benefits that he relies on to provide for his disabilities. So you got to be really careful with how we're going to leave money to disabled beneficiaries. Spendthrift just means that your kids aren't very good with money. I'm sure none of you have that situation where you're worried about giving your kids some money, what they're going to do with it, but it happens sometimes. So sometimes we need to set out, how things are going to be managed for people over time. Same thing for like young children. If you've got money going to a minor child, you don't want that money to just go to them until they're 18 and then have it drop in their lap when they turn 18. You want to sort of set it out to where they can have some help managing those funds until they reach a responsible age. What happens to my qualified money? This is always a very important question, something you should absolutely talk to your financial advisors about, how to make sure that your qualified money is going to be used in the best way, both during your lifetime and how we're going to transfer that money out to your kids. It's very, very important. And proper planning, what do they say? Proper planning prevents poor performance. Understanding your tax ramifications versus your kids' tax ramifications if they were going to inherit that money, especially if they're inheriting that money during their peak earning years, can have a real impact on both you and them. Farm and business succession planning, I encourage you to come back to talk about that if you have either land right now, or if you're going to be inheriting land someday, boy, that's super important to know how that's going to work. And then I know there's no responses in here, but should I worry about my remarrying, disinheriting our children, right? You think that would never happen? It happens way. When you've got second marriages late in life, you need to be very, very, very careful with understanding who's going to be entitled to what and how those things are going to work out after they're gone. So that's my general spiel about estate planning. So wills, trusts. The reason that I go through and do that when I'm preparing to talk about Medicaid is because one of the tools that we have that is a real benefit when it comes to qualifying for either VA benefits or the state's Medicaid program is a kind of trust that we do. So when it comes to asset protection for long-term care cost, there's a variety of things that we do. So the two main benefit program plans are Medicaid planning, that's available for every person that's that lives in the state, and then VA pension planning. That's appropriate for people that are veterans or the surviving spouse of veterans that served a period of time during wartime, and I'll talk about that at the end. It's an awesome benefit that a lot of people don't recognize that they earned through their military service that goes untapped all the time. So how to pay for long-term care. Long-term care insurance is an awesome tool. When people come to me and they say, my loved one is getting ready to move into long-term care, we're worried that, we're worried about how we're going to pay for it, but we have this long-term care insurance policy. For me, it is like Willy Wonka's golden ticket, because what it does is it buys time. So yes, it pays for money at the facility, but one of the key tools to benefit planning is time. You can self-insure, which just means I'm going to save my penny, and if I need to be in long-term care, I'll pay for it myself. Or you can apply for either the state's Medicaid or VA pension, or a VA pension program called Aid and Attendance. When it comes to, there's two main times where you can plan to qualify for Medicaid benefits. One is if we have 5 years prior to somebody applying for benefits in an assisted living or long-term care facility, and the other is the day that you're moving into the facility. So the state has this rule that everybody's heard of. It's this 5-year look back, right? You guys heard of the 5-year look back rule? Well, what it means is if you've got $1 million in your pocket and you're getting ready to move into a long-term care facility, the week before you move in, you can't just give it to your kids, move into the long-term care facility, and then have the state pay for your benefits. So what they do is the state says, well, if you gave away $30,000 and then between your income and the cost of the facility and, they have this formula that they apply, well, that $30,000 would have paid for, 4 months at the facility. Somebody's got to pay for your care for the next 4 months, but it's not going to be the state of Iowa. And so they penalize you, not based on dollars, they penalize you based on time. So the key is, but the key is they don't track transfers that happened less than 5 years ago. And so the key to pre-planning for Medicaid is structure your resources accordingly, so that way assets aren't held in your name more than 5 years before you're going to be applying for benefits. However, there are some exceptions to this transfer rule. Disabled beneficiaries is one. So I had a situation where both mom and dad moved into a long-term, their bill was going to be over $20,000 a month in the care facility. The only asset that they had was the family, maybe $15,000. So that wasn't even going to last them a month. One of their 3 was disabled. And so what we were able to do is we were able to transfer the entire farm to the disabled child, save the family farm from the nursing home based on these Medicaid rules. Otherwise, they would have applied for Medicaid when they ran out of cash. The state would have billed and billed and billed and billed and billed for their time in the facility. And then when mom and dad passed away, they would have said, we want our money back. And they would have forced the sale of the family farm. By knowing the rules and knowing that if you transfer that family farm ahead of time to a disabled child, it's a protected transfer, then we can save the farm. Caregiver children. So if a child moves into the home of their parents and provides care for them for a period of 2 years or longer, then when they go, but if they transfer the house prior to applying for Medicaid, the state will not penalize them for that transfer. It's basically like, you've moved in with your parents, their house has become your home. So we'll allow you to transfer it to yourself without any penalty. Thanks for keeping your parents out of the facility for the last 2 years. Transfers between spouses, and then transfers to purchase exempt items. And that exempt items issue is going to be important to recognize when we begin talking about the crisis planning that we have. So when it comes to pre-planning for benefits for either non-veterans or veterans, there's an irrevocable trust that we do. A revocable trust, like I described before, is like your shadow. Put your house into the irrevocable trust. It goes where you go and does what you do, and it's just sort of part of who you are. An irrevocable trust is like making a new member of your family. And that family member's only job is to hold my things until I pass away. So that way, if I ever need to move into assisted living or long-term care, these things that I put over here are not subject to the state's forced spend down. Some people will do what they do with their checking account, which is like, oh, I'm just going to put my house in my kid's name, and so that'll do the same thing, right? Well, the problem with putting your house in your kid's name directly, you have the same problems with the checking account. Your house is now your child's. If they get divorced, your house is part of their divorce negotiation. If they get sued, your house belongs to them. It's not exempt because it's not their primary residence. If they die, your house is part of their estate. The other problem with putting
I want to back up just for a minute and clarify a few things maybe with you and our audience here. So Medicaid is a government program for healthcare for those of very low means. Mm-hmm. And when we say very low means, what does that mean?
If for a single person, it's $2,000. So you have to be destitute in order to qualify for this benefit program.
So if you're single, you can only have $2,000 worth of property.
Accountable assets.
Okay.
Details.
Yeah, basically someone of very low means. Mm-hmm. And so what Chad is beginning to talk about is how do you qualify for Medicaid if you have more than
$2,000.
$2,000. So these are some strategies.
Yep.
So from a married standpoint, what is it?
So married, it works a little differently, and we'll talk about that here in just a minute.
Okay.
But it's basically the spouse can keep half of their marital assets that are countable. Some things aren't countable, like your house and a car and prepaid funeral plans, things like that, up to a maximum of $150,000. So if you have $200,000 of countable assets, the spouse can keep $100,000. If you have $300,000, you can keep $150,000. If you've got $1 million, you can keep $150,000.
So all these strategies are to kind of like this other family member to get assets out of your name into a trust's name. So when Medicaid looks at you, mm-hmm. they don't see that you own anything.
Yeah. Or at least it substantially shrinks the things that I own. So that way, if things do need to be spent down, we're not talking about spending down everything.
Yeah.
We've already set things aside so that those things wouldn't be subject to that forced spend down.
So again, this Medicaid planning is an advanced area of estate planning to have to qualify yourself for Medicaid, which does pay for long-term care.
That's exactly right.
In certain situations.
Yep. You're exactly right. And I guess I should have said this earlier. So the Medicare and Medicaid sound an awful lot alike, and they're two totally different programs. Medicare is our federal health insurance program that everybody qualifies for. Medicaid is the state's program that covers all kinds of stuff, everything from formula for young moms to nursing home costs at the end of somebody's life. And so there's this giant umbrella of things that covered. Our firm deals a lot with helping families access the state's Medicaid program to help with assisted living and long-term care.
Gotcha. Okay. Is everyone clear?
Yeah, I'm clear, but it's 5 years.
Okay. So, hold on. So these strategies that he's going to be talking about now are to qualify yourself to be in the Medicaid program, which again, Medicaid looks at you and you can only own a very small amount of property to qualify for the Medicaid. So these are the legal strategies out there that are happening that people choose to enter into to qualify for Medicaid.
Yep, exactly right. And to answer your question, there's two, like I said before, there's two main times that we can do this. One is if we have time, you know, if you're in your late 60s, early 70s, and you're relatively healthy, and we're like, well, I've got years and years before I'm going to be moving into long-term care. These are great strategies. If you're 90 years old, if you have an Alzheimer's or dementia diagnosis, and you're likely going to be moving into assisted living or long-term care sooner than this, then there are other strategies that I'm going to talk about in a little bit that deal with what do we do in that crisis moment? Or if you have a stroke or something like that, that you're just moving in right away, what in the world do we do? So this is what we're doing ahead of time. So one of the strategies that sometimes people will choose to do is direct transfers to their loved ones. Fine, oftentimes causes major tax problems that they don't anticipate. My grandparents bought a house in Ames in 1956. They bought it for $8,000. And when they died in the mid 2000s, it was worth, $250,000 or so. Shortly before they passed away, they had considered putting their house into my mom and her siblings' names. And thank goodness they were talked out of doing that, because had they transferred the house to my mom and her siblings, when they would have sold it, it wasn't their primary residence. They would have gotten hit with capital gains tax on the difference between what it was worth when my grandparents bought it, what it was worth when they sold it. So it'd be probably 25% of $250,000. That's an enormous bill to write a check to the federal government. Because they owned it when they passed away, the IRS adjusts the tax basis on that property, and then it comes to them, they sell it shortly thereafter. You don't have to pay hardly any capital gains tax. So by putting your things into a trust, not only does it cure the issues with transferring things directly to your kids and all the risk that goes along with it, it also preserves a really awesome tax advantage. So once the 5 years goes by and your things have been in this irrevocable trust, it's like you never owned them. And so an irrevocable trust is a really awesome tool to protect certain things that you have. So things like real estate, super easy to go into an irrevocable trust. Life insurance, super easy. Cash, like post-tax investments that you have, CDs, money market accounts, those sorts of things, go into a trust. Stocks, bonds, brokerage accounts, all those sorts of things. The one thing that an irrevocable trust can't have in it is pre-tax retirement dollars, because the federal government requires us to own those individually. They're part of our personal investments. And the only way to pull those out and put them into an irrevocable trust is by doing some sort of conversion of that qualified money to non-qualified money. That is one of the reasons that everybody should have really good financial advisors, because they're going to have knowledge about those things that I, as an attorney, absolutely don't have. I know what we can protect. I don't understand how the ramifications of cashing and transferring those things out do. Please talk to your financial advisor. They know what they're doing.
I want to add just a little bit more, and this is expanding on what Chad's talking about, is this part up here really makes a difference, this irrevocable trust. So we talked about a revocable trust earlier, which is used. Revocable means you can change it during your life, right? You're in charge of your revocable trust. You can revoke it. You can take everything back. And that keeps your assets out of probate.
Exactly right.
Okay? An irrevocable trust is the opposite of that. Once it goes in, you don't have control over it anymore.
Right. That's exactly right. So,
there's always a caveat in law, right?
That's exactly right. There's always something, always an exception to the rule. So you're absolutely right. So with an irrevocable trust, what we want to do is be able to tell the state, hey, that doesn't belong to me anymore, belongs to the family trust. I can't change it, and I'm not in charge of it. So that it's off the table, it doesn't have anything to do with me. So functionally, the way that it works is with a revocable trust, I'm usually the trustee of my own trust, right? I'm managing my trust however I want to. With an irrevocable trust, I want to put one of my other family members on, one of the ones that I trust and will do what I tell them to do, in as the trustee. So that way I can, I mean, not just can just say to the state, but it's the truth. I'm not in charge of that money anymore. My loved one is. Additionally, I want to be able to say, I can't change it. Now, does that mean it can't be changed? No. So there are mechanisms that are built into the trust for a role called a trust protector that can get in and shift things around. So like if the law changed at some point in the future, or you had some sort of weird catastrophe in your family and we needed to update things to make sure that it's going to comply with what your wishes are, there are mechanisms to be able to do that. But what you want to do is, like I said, put things in your irrevocable trust, let them sit there for 5 years, and after they've been in there, they're guaranteed that they're going to be protected from the state, from having to be spent down on your care.
That's right. So I'm Medicaid, looking at your situation. If you have your assets in a revocable trust, I'm saying, nope, you still got control over your assets. Those are yours. You don't qualify. If it's in an irrevocable trust, like this situation over here, I look at Chad and he doesn't have those assets because they're in that irrevocable trust and he can't control them. So he does qualify because he did that move. And Medicare had this rule that they're looking for moves that you made in the last 5 years. That's that 5-year look back rule. So that's just to, so the idea of planning ahead is to do this in essence 5 years before you think you need to.
Yeah, exactly right. And I mean, sometimes things come up where you don't anticipate it. Like I had a family that I did this planning for, and then 6 months later, dad was in a car accident. Right? There's no way to plan for something like that. Even in those situations, and we're going to talk about how that works in a little bit, there are still mechanisms that we can do to shift things around and protect them. But absolutely right. So the goal is to divest yourself of some of these resources, but you're not losing it. You're going to lose it to the nursing home, or you're going to lose it to the state. What we want to do is we want to lose it to the family trust, so that way it's protected for my loved ones when I'm gone. Like I said, this is a good tool to protect some of the kinds of things that you own. Can't protect everything, but with proper planning, you can preserve a lot of your resources. So we've got a case study. We're not going to get into that. It'll take more time. So that's that pre-planning side of things. But what happens if we don't have 5 years? And this is where things get super complicated. So if somebody moves into a facility, then you're usually in one of three situations. Either dad's moving into the facility, mom has already passed away, so we've got a single person. We've got dad's moving into the facility and mom's staying at home. We've got both spouses moving into the facility. So each different kind of plan or situation has a different kind of planning, and there's a different plan for all three. The one that we're going to talk about, which is the one that we see a ton of, is mom or dad is moving into the facility, well spouse is going to stay at home. Well spouse and one of the kids comes into my office and they're always in tears because, you know, dad's had this medical event. Mom's like, I'm going to have to eat rice and beans every day for the rest of my life because the nursing home costs $12,000 a month. They're my best days at work, because what I get to do is I get to say, I know that you're scared, but if we structure things correctly, you can preserve your resources for the well spouse in that situation. So how much money can you keep? We already talked about this. The Medicaid applicant can't have more than $2,000. This number's based on last year's numbers. The amount now is a little over $150,000. So the maximum of $150,000 over half of their assets. So like I said, if you've got $200,000 in countable assets, your well spouse can keep $100,000. If you've got $1 million, the well spouse can keep $150,000. So the key to the planning is so the easiest way to think about it is your money, when Medicaid looks at it, is like air in a balloon. So when you go into a facility, the state, no matter how much money you have, as long as it's more than $25,000, says you've got too much air in your balloon and you've got to spend some of it before you're going to qualify for benefits. So the question is, how are you going to spend that money? If you talk to the nursing home says, oh, you're just going to pay us month after month after month. And once your balloon has not, $150,000 worth of air in it at the most, then you're going to qualify for benefits. That doesn't do mom any good who's staying at home. So Some of your assets are exempt though. So if we've got a well spouse, the house is exempt because they're not going to make, you know, if dad's moving into the facility, mom doesn't have to be out on the street. One vehicle, life insurance with either no cash value or very low face value, irrevocable burial contracts, burial plots for family members, personal belongings, all of those things are exempt. So what the state is looking for is money. Checking, savings, CDs, money market accounts, annuities, life insurance with a high cash value, brokerage accounts, real estate, all that sort of stuff.
One quick question. So if you
Yep.
have a house worth $750,000, they're not looking at that. You still have $150,000 you can keep outside of these assets.
So that's a great question. And it's one of the things that I always am curious as how Medicaid looks at this. So technically Medicaid in the rule book has a rule that says, you know, the house can't be worth more than, usually right now it's about $650,000.
I see.
However, the state never applies that rule. And so we have, not only do we have the house, sometimes you have the house that's surrounded by its adjacent land. And as long as the land is contiguous to the house, they'll say it's all exempt. So not only does your house exempt, so are the 250 acres of farmland around it. And so that's worth way more than $650,000. So, but the state just is like, oh, it's exempt. We're not going to look at that. It's one of the very few things that the state is actually generous with people on. Other than that, they'll try to get every last nickel that they can.
Okay, thank you.
Yeah, absolutely. So, So one of the techniques that we have when it comes to getting resources from ill spouse to well spouse is resource transfer. And one of the things that the state allows you to do, and we talked about purchasing exempt items. One of the things that they allow you to do is purchase what's called a Medicaid compliant annuity. I'm not a financial advisor. I don't know anything about annuities except that this is a tool that works pretty regularly. So if what we have are $300,000, it's all of countable assets and it's all in a CD. Rather than taking the $150,000 that you can't have and just giving it to the nursing home, what you can do is you can take the $150,000 of resources and you can buy a Medicaid compliant annuity that immediately shrinks your money down. So where you have $150,000 cash, you got a contract with the annuity company, and then that annuity company immediately begins giving you that money back. And it can give you that money back. I mean, we've successfully done it up to about $20,000 a month, where that money just pays back and pays back and pays back real fast. So you shrink your money down, you get qualified for benefits, and then within the next year or whatever, your balloon is right back up to where it was before. And so the state says, totally appropriate. Again, I'm not a financial advisor. These tools work. So if you have questions where somebody's going to be moving into a long-term care facility, we can work with your financial advisor to maybe reshape your resources to look at some of those annuity products to be able to transfer your money. So that way you're not just losing everything in the process. It's a much better solution. Then the last thing that I want to talk about is Veterans Affairs Non-Service Connected Improved Pensions. It's a mouthful. Commonly known as aid and attendance. So aid and attendance is a reimbursement for your out-of-pocket medical expenses if you need assistance, and that's assistance in the home or assistance in an assisted living or long-term care facility. My grandfather served in Korea. He was a prisoner of war, got out of the military, worked at the veterans home in Marshalltown for 30 years, retired, moved down to the lake with grandma, got sick, and was in an assisted living facility for about 3.5 years. During that time, we didn't know that these benefits existed. This is before I was an attorney, and we never made an application for the benefits. He would have qualified for about $60,000 of money that my grandmother, who's still alive, could really use. Didn't ever do it. And so anytime I'm able to come out and talk to people, if you served, if you're a family member of somebody who served, if your next door neighbor served, and they are in need of some assistance, this is a benefit stream that we can flip on pretty easily to get them some extra money. So for 2023, and again, I sent this over before we updated the numbers. If both spouses were veterans that served during wartime, they're going to qualify for a little over $3,500 tax-free into their account every month to help pay for an assisted living facility. If it's a married veteran and both veteran and their spouse are moving into the facility, it's $2,642. If it's a single veteran, it's more than $2,200. And if it's the surviving veteran, this number is up over $1,500 a month. So if dad served in the military during Korea or Vietnam, he's passed away, mom's moving into a long-term care facility or assisted living, and she could use an extra $1,500 a month, his service will just allow her to flip this pension off. So what are the eligibility requirements? So it had to have required military service, medical need, and then a combined income and asset test. So they had to have served 90 consecutive days, one of which was during wartime. These are the sort of wartime periods that are common. So even if he was stationed in Alaska during Vietnam, by virtue of him having 90 consecutive days of military service, one of which was during wartime, he'll qualify for these benefits. Medical needs, these are the things that you would expect somebody to be medically needy. You know, they need assistance with 2 out of the 6 activities of daily living, which include meal preparation, medication management, bathing, toileting, dressing, all those sorts of things. If they need help with a couple of those things, we can flip that on, okay? And then income and assets. So unlike Medicaid, where you can only have $2,000, with this VA benefit, you can have $150,000 and qualify for this. So oftentimes what happens though, is dad's got $80,000 in the bank, he's got his house, and he's moving into assisted living. Well, he'll qualify for benefits because the house is exempt, $80,000 is underneath here. Moves into the assisted living facility, what's the first thing that people do? What do the kids do when he moves in? Sell the house, that's right, which turns an exempt asset into an extra $200,000 cash, and then dad loses his VA benefits. One of the advantages with the VA program is the VA, especially for the house, has no look back period on transfers. So if I do a Veterans Assistance Protection Trust on Monday, I put the house in it on Wednesday, we sell the house on Friday, the proceeds from the sale go into the trust, they don't go back into dad's pocket. Dad has his $80,000, dad has his VA benefits, and the trust has the proceeds from the sale of the house. And so it's a way for us to be able to keep that. So knowing the order in which to do things is a lifesaver with some of these things. So that is my spiel. So if you know somebody that's a veteran, we can help them get qualified for the benefits. So
I think one of the themes here is thinking ahead, planning, getting together with an attorney and asking questions about your specific situation. I did want to cover one more thing and ask you actually a couple more things. So let's say you do the irrevocable trust. Mm-hmm. You get many of the assets into trust to protect it for later. And you're in their services for a number of years. Yep. And the state is basically going to keep track on how much they've spent on you. Mm-hmm. So let's say it goes up to something like $300,000 or $400,000. Mm-hmm. What happens if you pass away?
So they file a claim in your estate that says we want our money back. And so this happens pretty regularly. You know, you're able to keep your house and qualify for benefits. So mom moves into the facility, they keep the house. The house is worth $180,000. Mom develops $220,000 worth of debt to the state. The state forces the sale of the house, pulls that money back to the state. We had a situation where dad was on benefits a long time. He developed about $280,000 worth of debt. Mom really only had a little bit of cash and the house. She wanted to be able to leave that house to her kids. You can do a Medicaid trust, put the house in the trust. It doesn't belong to mom when mom passes away. The house goes to the kids. The state gets whatever small amount is left in the checking account.
Okay, so another clarification is if it is a married couple and the ill spouse has racked up some debt, it's a claim against the estate, but not until
both spouses have passed away.
Gotcha.
Yep. So if dad's in the long-term care facility and he racks up $200,000 in debt, he passes away, the state doesn't immediately come after that money from mom. The state says, after both of you guys, then we're going to settle up.
Okay. Because that's a big difference.
Huge.
Okay. So again, legal advice often worth its weight in gold. I did have one more question, then we're going to open it up to the group. When you talked about, at the beginning, you talked about the 2% fee on probate. And I just want to clarify, because we hear this a lot. It is not a rule. It is simply a maximum that attorneys can charge. Is that correct?
Yes. So you're exactly right. So I do probate estates for people all the time, where they come in and they say, well, my estate's worth this much. I'd like you to discount that sum. And I look at it and I say, okay, well, how complicated is this estate going to be? Is it going to be pretty simple? Sure, I'll discount it. Is it going to be super complicated and your kids all hate each other and you're going to fight and it's going to make all my hair fall out? I'm not. And so you sort of look at some of those factors. But it's also a misnomer, because the 2% is the maximum for normal administrative services. If there is litigation that is involved in the estate or other things, the attorney can also seek to get paid more than that based on the extra time that they have into it. You should be very careful with the attorney that you select to make sure that they're ethical, because we see people do ethically questionable things pretty regularly.
Mm-hmm. So I guess my point, and I've been through this estate process myself. So I just like to say, number one, it's largely negotiable. You can negotiate.
You bet.
And number two, sometimes maybe it's just best to hire somebody by the hour. So those options are out there. Again, doesn't have to be 2%. So I wanted to bring that up, but sometimes it is. So we're going to open it up. We have about 5 or so minutes left. Want to be respectful of everybody's time, especially online. What sort of questions do we have? A totally satisfied group? Chad, this is, okay, hold on here.
If you have a home on 10 acres and you have a deed that is transfer on death to your 3 children, does that protect it from Medicaid if one of the spouses has gone in and racked up more than the value of the house on 10 acres?
It does not. So if you own something, even if it's held in joint tenancy with somebody else when you died, the state looks at that as your asset on your date of death. The transfer on death deed is a little confusing, because Iowa doesn't allow transfer on death deeds. So if you have a house in Missouri or Oklahoma, that's too bad. My in-laws are from Oklahoma. I'd hate to live there. Just kidding, if you're watching. But Iowa doesn't allow transfer on death deeds. And so I'm a little, is the property in Iowa? No. Oh, okay. Yeah. So
it's just something that she read about.
Yeah. So oftentimes what they'll do is they'll put their kids on as a joint tenant, expecting that, well, when I die, it'll automatically transfer to them and then the state won't have a claim against it. No. State has a claim against it.
So here is one thing that I have learned as an advisor and going through this process personally, is a piece of paper changes the world with estate planning. And it's often about how you own how an asset is owned. Is it owned personally? Is it owned jointly? Is it owned by a trust? That's a piece of paper. Changes all this stuff. Questions? Other questions?
I have a child that is on Medicaid right now, has been for a long time because of medical conditions. And then I have 3 grandchildren that are intellectually disabled. I know that they're on Social Security also. How do I set up my will so that they get taken, the money goes to them?
Absolutely. So that's part of that what we call a supplemental needs trust. Very important tool to leave money to disabled individuals. It's something that you can build into your will or trust. So that way, not only them, but I mean, anybody that could become disabled in the future, if they're receiving benefits that are associated with their disability, it goes into a special kind of trust. It doesn't become theirs, so it doesn't impact their benefit pool. and there's money to use for the things that their benefits don't pay for. We do a ton of it. I've got family members that are disabled in my own family, so I've done this planning for my loved ones. It's really important to pay attention to.
Awesome. Another question right here.
May have two. We'll see. You mentioned the point or the power of attorney forms have changed recently. Was that weeks, months, or years?
No. So the last major change in the power of attorney forms were in 2014. So I say recently. I mean, if you had one done in the 90s, you should get it updated. It hasn't been like super recent. They've done it.
Okay. Secondly, it sounds like for the 5-year look back, if you make if you work a strategy designed to do that, but it turns out to be 2 or 3 years, is it prorated? Do you gain an advantage, or is it kind of an all or nothing?
It's all or nothing. If it's 1 day shy, the states doesn't want to pay a nickel for anybody they don't have to. We've got $1 billion surplus, and the state says, oh, even people that are profoundly disabled, if you've got a nickel, then you're not going to qualify for benefits. So you got to be super careful with how we're going to do this. So the key then is, let's say we make it 4 years out of the 5. Well, then we got to look at it and say, okay, well, do we want to go through all the work of pulling everything back out of the trust, reshuffling the deck on all the finances, use the crisis strategies to get people qualified and then refund the trust? Or do we want to find a way to come up with the ability to pay for that last year? And then, we've had to expend some additional resources at the facility, but certainly not 5 years worth. And so it's always sort of a balancing act, and coming in, and every family's situation is different. And it's all case specific. And so you come in, you do the math on it, and you say, okay, well, which one of these is the best solution given your circumstances?
All right. We have Steve here, advisor at Compass, with a client story.
So within the past year, I had a client who went through this. It was what you, Chad, referred to as a crisis planning situation. They didn't have the 5 years in advance. He just got too bad and had to go to a full-fledged long-term care facility. They had assets needed to be spent down, and when we think about spending down, in excess of what the spouse is allowed to keep, you're thinking, okay, I've got to spend all this money and send it to the nursing home before Medicaid kicks in. And that is not the case. In this case, they got spent down in a hurry. She bought a new car, which they desperately needed, got their kitchen remodeled, which was already on the drawing board, and then purchased one of these Medicaid compliant annuities. Yep. And we set it up for the shortest period allowed by law so that the money comes back to her as fast as possible. Doesn't matter. Once you've qualified for Medicaid, when that money comes back in, they don't care. Yeah. They're not going to reach back for it. And so they spent down in a hurry without sending any of the money to the nursing home.
Mm-hmm. Yeah. And that's one of the weird things about the way that our program works. Ill spouse gets qualified for Medicaid. If well spouse with 3 days later, ill spouse is still Medicaid. They don't care. After you've qualified for Medicaid, they don't care what happens with the well spouse, which is why the planning techniques work, because it's taking everything out of both of their pockets, putting everything back into the pocket of the well spouse.
I have an online question here. Right. We are veterans and have access to TRICARE for life. How does that interact with Medicaid? And are there specific, accurate resources we can review on how to educate ourselves?
Great. So TRICARE is the health insurance program. So what would make a difference when it comes to assisted living and long-term care is if there is a service connected disability that exceeds 70%. So if you've got a service connected disability where you're 70% or greater disabled, there are long-term care facilities that you can go into, VA approved. So not just the Veterans Home in Marshalltown, but like Sunnyview and Ankeny is one, that your care will be paid entirely by the VA. So it's not necessarily TRICARE, because TRICARE is just the health insurance program. But the ability to qualify for assisted living and long-term care costs has more to do with service-connected wartime disability.
Okay, we got 1 minute left.
So Chad, you spoke today mostly about assets, the asset test, but the Medicaid Title 19 also has an income test. Can you speak to that at all here, the time we have left?
And this leads to another thing that everybody hears about, nobody understands how it works, something called a Miller Trust. So the state says, well, you can't have more than X amount of dollars per year, and it's always tied to the Social Security numbers. And this year it's a little over $2,800 a month, and qualify for Medicaid. But there's plenty of people where dad's moving into the facility, he's got $3,000 a month worth of income, but his stay at the facility is going to be $12,000 a month. So there's not nearly enough to cash flow. So if you have more than the Medicaid limit, the state just makes you jump through an extra hoop, create a document called a Miller Trust. It just governs how your money's going to work. Functionally, it works the exact same ways if you don't have one. The only difference is the state gets whatever's left in the bank account, usually just a few $100s at the end of the person's life. If you have a married couple and dad's moved into the facility, mom's at home, mom's income is only $1,000 a month of Social Security income, dad has more income. Well, the state says, well, mom needs more money than $1,000 a month to live on. And so in that situation, another thing that's important to know about income is that you're able to divert income from the ill spouse to the well spouse to get them up to an appropriate amount. Changes every year. This year, that's about $3,800 a month. And so there's plenty of people where they've got $3,500 a month combined. Dad moves into the facility. All of their income stays with mom. Great questions.
All right. That was a power-packed hour. Chad, thank
Sorry,
you.
it's a lot of info.
Thank you so much. Advisors are here. Come talk to your advisor. Chad will be here for questions. Introduce yourself. A heartfelt thank you to clients. You are our growth engine. You are our purpose for being here. Thank you for choosing Compass. Thank you for your referrals. Thank you for your trust. And come back next month. See you soon. Bye.
Thanks, guys.
I like the yin and yang.
Absolutely.